Be ready. Start. We have heard the learned Additional Solicitor General of India, assisted by Mr. Dhaval D. Vyas, the learned Senior Standing Counsel appearing for the appellant, and Mr. D. K. Trivedi, the learned advocates appearing for the SSCs. We propose to first look into the question as regards the maintainability of the present appeals before us under Section 130 of the Act. According to the learned advocates for the SSC, the appeals filed by the Revenue before this High Court under Section 130 of the Act 1962 are not maintainable. It is argued that an appeal shall lie to the High Court from an order that may be passed by the appellate authority, except an order relating to, among other things, to the determination of any question having a relation to the rate of duty of customs or to the value of goods for the purposes of assessment. It has been vehemently argued by both the learned advocates appearing for the SSCs that the three appeals before us involves a question relating to the rate of duty of customs and classification, and in such circumstances the appeal would lie before the Supreme Court under Section 130E of the Act 1962. On the other hand, Mr. Devang Vyas, the learned ASG, assisted by Mr. Dhaval Vyas, learned counsel appearing for the Revenue, would submit that the appeals are very much maintainable before this court under Section 130 of the Act 1962, as the order impugned does not relate to any determination of any question having a relation of the rate of duty of customs or to the value of goods for the purpose of assessment. Para. The principal argument canvassed on behalf of the revenue is that if the imported goods is to be treated as the HST, then it is per se prohibited. In other words, the very import of the HST is prohibited. Any goods which are prohibited from being imported are liable to be straight away confiscated with imposition of appropriate fine and penalty. In such circumstances, there is no question of any determination as regards to the rate of the duty of customs or the value of goods for the purposes of assessment. The argument is that the court may not go by the operative part of the order in original. The plain reading of the operative part of the order in original may, in the first blush, give an impression that the Commissioner has classified the imported goods under the respective tariff item. The argument of Mr. Vyas is that there is no classification for the purposes of determination of rate of duty. The classification is the only for the purpose of identity of the two disputed products. Stop.